the circumstances under which Rocky grew up has no relevance in this case. And there's going to be no evidence of it. What happened in New York, how he grew up, whether he grew up poor, middle class, rich, none of that has any bearing on any decision that this jury is going to make. So there will be no evidence of his childhood. And speaking objections, you both know this. I know that in the heat of battle it tends to happen. I don't want speaking objections. Speaking objections are explaining to me why you are making the objection. If you make an objection, I know why. So just state the objection, state the legal grounds, but don't explain to me why. Everybody on the same page?
Yes.
Okay. All right. What? Does it relate to his opening statement?
It does.
What?
My co-counsel got up. He gave a legal opening statement. He didn't argue. He didn't bring up areas that are outside of what he was supposed to discuss. Counsel got up, and he basically gave an argument charge. I know it, the court knows it, he knows it. The problem is, I don't think he cares, because basically, he just talks about whatever he wants to talk about.
Don't make aspersions.
I'm not making aspersions. I watch as he continued to argue, point after point, and I just want to make sure there were several things that he said about what the evidence is going to show. So, for instance, he testified how bullets capture prints, and there should have been bullets on that gun. Well, as far as I know,
You mean prints?
prints on, excuse me, prints on the casing, prints on the bullets. They haven't put a witness on bullets to testify to that. He repeatedly called the victim in this case, quote, a proven criminal and perjurer. Now here's the problem. Last time I checked, has he made a motion as to what, if any, conduct the court is going to allow? It's absolutely improper. Had a prosecutor done that, can you imagine, just imagine for a moment, if he had gotten up and made aspersions about what happened to, for instance, the defendant in Sweden without having brought it up to the court's attention. I counted 10 different times when he called the victim a perjurer. At least 5 times when he talked about how he was a proven criminal. Unless I missed it, Your Honor, where did he get the court's permission to be able to introduce that evidence? As the court remembers, I said yesterday to counsel in the court, all that I ask is if there's an area that you're going into that is not absolutely clear, you approach and you make sure you can do it. So, Your Honor, it's not just a disrespect to me, to my co-counsel, it's a disrespect to the court, because he has basically decided, I'm going to say whatever I want about the victim, and I don't care whether it's going to be allowed by the court. And the problem is,
I see your point.
Okay.
Why are you telling me this now?
Well, Your Honor, I objected during, why am I telling you this now? Very simply. I objected during his opening.
Right.
The court's position, it's clear to me, the court understands that much of what he said was objectionable. The court said, I'm not going to stop somebody on opening.
I'm reluctant to grant objections during opening statements, no matter who is making the opening statement, whether it's the people or the defense.
So what I'm requesting is I want the court to instruct this jury specifically and very simply. Defense counsel made certain allegations. He called the victim in this case a criminal and a perjurer.
I know. I'm not going to do that. What I will remind them is nothing that you say or any of the lawyers say is evidence. That is what I'm willing to remind them of that. And that's the end of the issue now. Once the witnesses testify, if you think that there's an objectionable question, object, and if you're right, I'll sustain the objection in a hot second.
Understood, Your Honor.
All right, let's take a break.
No.
No response is necessary.